The Honorable, the Supreme Court.
Thanks very much. Morning again, please be seated. And go ahead, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Beryl Dewdney and Cordelia Dewdney versus Ralph E. Duncan IV, case number 24AP066. Representing the appellant, Beryl and Cordelia Dewdney, is Justin Barnard. Seated at counsel table with Justin Barnard is Ann Barden Rosenblum. Representing the appellee, Ralph E. Duncan IV, is Sharon Annis. Seated at counsel table with Sharon Annis is appellee Ralph Duncan.
Thanks very much. Good morning again, everybody. Counsel for the appellant, please come on out. If you would, for the record, introduce yourself and identify your client.
Yes, thank you, Your Honor. Good morning, may it please the court, Justin Barnard, for the appellants, Beryl and Cordelia Dewdney. This appeal places before the court several consequential and very sharply disputed questions of law. But to place these questions in context and begin to unravel the issues raised by this appeal, let's start with what is not disputed here. Neither the trial court nor the appellee have contested the notion that the sort of conduct that has been alleged in this case and that appellants seek the right to prove at trial is exactly the sort of misconduct that law has long condemned and considered an actionable wrong. Appellants have alleged and have offered evidence that their mother, Anna Dewdney, while she was battling a terminal brain cancer, was pressured by the appellant to make a change in her trust that substantially benefited him and reduced the benefit.
Mr. Barnard, this is a revocable trust. And so until the settler passes away, the person can modify the trust any way he or she wishes, correct?
That's correct here, and we're not claiming otherwise.
And so if she has the ability to modify the terms and conditions of the trust, doesn't with specific notice potentially to your clients, wasn't there an obligation at that point to potentially challenge the circumstances and the facts?
I think Your Honor, only if you assume that my clients had all the facts that would give them cause to challenge. At the time that they became aware that the trust had been amended, they were told by their mother and they were told by appellee, who affirmed it, that she had agreed to this requested change in her trust based upon an express agreement by Mr. Duncan that he would maintain both Beryl and Cordelia as his heirs for the rest of his life, and that he couldn't change that.
In his will. That would be in his will, not part of a trust agreement.
Not part of the trust, but it was the consideration for doing something that the record shows, the undisputed evidence shows that she had previously vehemently rejected. He asked her to change the trust earlier in her illness, and she said, I'm not willing to do that, to the point that she reached out to two attorneys who were representing her and said, can I entirely remove appellee from my estate plan and leave everything to my two daughters? It was only later in her illness, after she had grown more debilitated, more dependent upon the appellee, who was not only her primary caretaker, but also stood in a fiduciary role with respect to her as the agent under her power of attorney and as the trustee of her trust. It's only after he applied pressure and he made this promise that he is now disavowed that she agreed to make this change. And under these circumstances, Your Honor, the law has always provided that undue influence and fraud, even though someone retains the ability to change a trust up until the point of their death, if that change is procured through fraud or undue influence, it can be challenged.
So didn't the daughters, then your clients, have noticed that there might have been undue influence and contested the trust in probate court? And your argument is that your clients didn't know anything was amiss until the appellee allegedly said, there's no contract for me to leave you in my will. But from what you just said, it sounds like you agree that there was some concern at the time the mother changed her will that, in fact, there might have been undue influence.
I don't believe that that's true based upon the record, Your Honor. And first off, from our perspective, whether they had concerns about this change is not material, given that what the claim that we've made, intentional interference with an expectation of impairments, it has a 6-year statute of limitations. So we're not talking about whether this claim accrued at that point and then had run by the time they filed suit. They filed suit within the 6-year statute of limitations. The only reason that their knowledge would be material is if the court accepts the notion that there is an exhaustion requirement. You have to go to probate court. And if the court is inclined to do that, I understand that the third restatement, articulates this exhaustion requirement. I would urge the court to read the comments and pull to the third restatement and the cases out of which the third restatement arose, which made clear that the concern and the impetus for this exhaustion requirement was the concern that people who had had a chance to challenge a will, because a will is always going to be probated. Before it becomes effective, the court has to allow it. Litigants who had that chance might try to do an end run around the probate process and bring a tort claim.
But isn't under the trust law 14A, under Rule 406, isn't there a provision that allows the ability to challenge a trust for undue influence?
There is, Your Honor. And again, at the time that my clients learned that there was a change in 2016, they were assured by their mother, I'm making this change because Mr. Duncan assured me that he is going to preserve you as the sole heirs under his will, and I wouldn't make it otherwise. And she said, there's no way that he can give his money to anyone except you two. That's in the record at CPC 88. She was clear that she understood that this change in her trust, which she had, again, vehemently rejected earlier in illness, she was making it only because she had received this assurance. Under those facts, if there was a fraudulent promise, that would be sufficient to challenge the validity of a trust. Yes, under 406. But they didn't know it was fraudulent, that it was a lie until 2021.
But doesn't this, I'm missing something here, I guess. Your clients are supposed to be the heirs at law under his will. And according to what you just said, this was the arrangement as part of her deal for changing the percentages in the trust. And that they were going to get was in his estate. And you said he can't do anything else with the money. He can't give it to anybody else except you two, but he can spend it.
Yes, he can spend it, and that was the choice she made. She said he's not going to be able to spend it all. And it was, again, she had already said, I'm not making this change. I do not want to change the trust. And to induce her to make that change, he offered her an assurance that he's now disavowed. Whether or not it was an ironclad assurance that would give them the same consideration that they would get as beneficiaries under her trust, I don't think that's the question. The question is, was the promise that induced her to make that change, was that, the inducement, was it material to her decision, and was it fraudulent? And
the promise hasn't been reneged on yet.
Well, he's repeated his promise. He said, I never promised anything like that, and I have no legal obligation. And the fact that they are, in fact, or at least were during discovery, the heirs under his will, that can change at any time. And the benefit of the promise that he made to Anna Dewdney was, you are getting security for your daughters. I'm reducing the security that you provided under your trust. And in exchange for that, I know you didn't want to do that. In exchange for that, I am committing that I cannot change my will. That they will.
The changing of any time, and there's lawyers involved in this transaction as she's obviously extremely ill to the point of death, and but nothing was ever confirmed with a specific, like a writing, a separate writing saying that there was an agreement. I agree that I will never modify this will that allows your two daughters to be the sole beneficiaries of my estate if I were to be post-deceased you. There's nothing in writing whatsoever about that, is there? So under Vermont law, someone can change their will at any time that they wish, as long as they're of sound and appropriate mind. It's
correct that wills are ambulatory and people can change their will at any point. But the court has long held that, an oral promise that otherwise might fall within the statute of frauds can be made enforceable by virtue of performance and reliance. And here, Anna Dewdney fully performed. She did the thing that Reed Duncan was pushing her to do, which was make a change to her trust, giving him a significant benefit.
And Mr. Barnard, as to the notice issue that was raised by one of my colleagues previously during your oral argument, there's a distinction between the trust and wills, because trust, as a matter of course, do not go through probate like a will does, correct?
That's correct, Your Honor. And that's the ground upon which the Sachs v. Dissinger case out of Massachusetts, which is the only case that is addressed at any length how this exhaustion requirement for intentional interference claims would apply to trusts. That's the reason that the Massachusetts Supreme Judicial Court said that the exhaustion requirement does not make sense in intentional interference claims that relate to trust.
Yeah, but I'm sorry.
No, please.
But what about the Collins case, 2017 case, in which we, I think, restated a commitment in the law to probate jurisdiction, exclusive jurisdiction over trust? How do you respond to that?
So Collins, Your Honor, raised an entirely separate set of questions. In Collins, you had a wife in a divorce proceeding who was seeking to pull into the marital estate trust property when her husband's father had amended the trust during the divorce proceeding to name another beneficiary. So to actually get the benefit of that property moving into the marital estate, the family court would have had to directly invalidate the trust, because it would have, the only way that property would have moved into the marital estate is if the amendment were invalidated. So it directly raised a matter that was within the sole jurisdiction of the probate. When you have a claim for intentional interference, a just enrichment claim, or constructive fraud claim, all those claims are outside of the probate process. They depend upon the change in the trust, if we're talking about the trust, being effective, because someone is not harmed. They do not suffer a harm that would give rise to an intentional interference claim or an unjust enrichment claim, unless the instrument that was affected is held effective and the property actually passes.
Yeah, but certainly the other process, if I can refer to it that way, of the infliction of impact on an expected inheritance. I mean, that has an impact on the administration of the trust, does it not? The result of that would have.
It does not. And that's one of the key points that a number of the cases made out of Illinois and the Sachs case, that when you're talking about a tort claim, it does not affect the administration of a trust. You are seeking to hold the tortfeasor liable for their wrongdoing and obtain a recovery from them. It does not slow down the administration process, and there are good reasons why the court or the legislature has set sharp limitations periods for challenging the validity of the trust, because you want to be able to administer a trust efficiently, and you want a trustee to be able to dispose of trust property within a reasonable time after a settlement of debt. Whereas a tort claim doesn't impact that. If there are other beneficiaries who would take under a trust, they're still going to take under the trust as you pursue a claim against the tortfeasor. That is a critical difference, and it's one of the reasons that the Uniform Trust Code, which sets this limitations period, said unambiguously in its comments that the limitations period under 604 does not apply to intentional interference claims because they are not trust contexts. They don't affect the trust property.
All right, I have a question. I realize you're trying to save some time here, but with respect to the intentional interference claim, and also you've argued in the alternative breach of contract and other things, is there a difference in the measure of damages under the intentional interference claim versus the breach of contract? And more broadly, what are the damages?
The damages, Your Honor, would be restitution for claims for constructive fraud and unjust enrichment. And the law has long provided that restitution stands in cases like this where you claim undue influence in the procurement or alteration of the gift. For the contract claim as well, we've made a claim for restitution, which is why the trial court's analysis denying anticipatory repudiation doesn't make sense because the courts have held that where you're seeking restitution and there is an anticipatory repudiation, you can bring suit immediately. As to the intentional interference claim, Your Honor, it would be damages in the amount that they've been harmed, namely the loss of the intended benefit under the trust.
But how do we know that they've lost that?
We know they've lost that. I mean, that would be for a jury to decide. Did Reed Duncan's conduct tortiously interfere with what was a defined intent over time by Anna Dewdney? If it did, we know exactly what the measure of damages is the difference between what they stood to receive under the trust before the tortious interference and what they actually received. That's a figure I can give you today.
But they've been receiving under the trust right along, correct?
They've been receiving a reduced amount of the trust, Your Honor.
Right, and then there's an expectation that in the will, they'll be the sole heirs. And we don't know that whether that's going to happen yet or not. So I'm having a hard time getting an anchor here on what the damages actually are.
The damages, again, if we prove our claim before a jury, we're entitled to restitution under most of our causes of action. And that's a clear, easily administrable remedy because it's clear, it's just simple math. I'm going to reserve my.
All right. Thank you. We'll hear from the appellee, please, counsel. Introduce yourself and your client.
Thank you. Good morning, and may it please the court. My name is Sharon Annis. I represent the appellee in this matter, Ralph Emerson Duncan. We call him Reed. And we are here to defend the trial court's grant of summary judgment on all claims before the court. As this court well knows, sometimes an appellee is up here to defend a trial court's decision, although we may not agree with the legal process that they arrived at it. But I'm here to tell you today that the trial court, in our opinion, got this unequivocally right on all counts and issued a decision that we believe will stand up to the scrutiny of the Supreme Court. And we do urge the court to affirm it in all its respects. And in the interest of time, as regards the promissory estoppel, unjust enrichment, and constructive fraud arguments by the appellants, I'm just going to say that I believe that the trial court's decision was based on well-settled Vermont law and on the solid material, undisputed facts. Appellants certainly may try and obviously are trying to shade the undisputed material facts to fit their shifting narrative, depending on what claim they're talking about. But ultimately, the basic material facts and application of the settled law fully support the trial court's conclusion. So what I'm focusing on today are the two sort of novel claims before the court, beginning with intentional infliction, intentional interference with expectation of inheritance.
Ms. Annis, before we get there, can you just, does the appellant have or the appellants have a remedy in the probate division?
They did. They had an available remedy, as the many cases have defined it, and under the third restatement, there was an available remedy for almost their exact claim, which was what Your Honor referred to, the 14A VSA 406, the undue influence claim. That's the same type of claim. It puts a different focus on the claim in terms of it's not on an individual tortfeasor, but it is the gravamen of it is the same, was undue influence and fraudulent circumstances attendant to Ms. Dewdney's alteration of irrevocable trust.
And how about 604 under Title 14A, which just looks at the validity of the trust? Does that apply in any way?
Yes, I believe that would have been their avenue under probate to assert their claim that undue influence was applied to Ms. Dewdney to rob her of her free will and induce her to change her irrevocable trust before her death.
But there's no question that the trust was valid. It just could have been adjusted in a way that was allegedly improper.
The trust is indisputably valid, and in fact, appellants have said over and over in pleadings and asserting that they have no intention, they never had any intention of challenging the trust, which sort of leads to the disconnect. Well, if it's a validly executed trust amendment, where is there the undue influence? And their argument on that is that because they're focusing on their claim that my client acted as an individual tortfeasor and acted inappropriately, that would be the basis for their claim. But what they're missing or don't want to recognize is that it's a policy decision that the vast majority of states that have addressed this and adopted the probate exhaustion limit have balanced, is the policy between recognizing the integrity, the effectiveness, the legislatively enacted scheme in probate court, and making sure that that's the primary focus if such a claim arises, and only if there's no available probate remedy, that then the IIEI tour would be an option. What appellants don't seem to recognize is that this analysis contemplates a two-step analysis. First, stop probate court. If there is no available remedy, and it doesn't have to be the same one, as the third restatement tells us, an available remedy. If there is no available remedy at all, then you can bypass probate court and go to the civil court and assert this intentional tort. It's not an either or situation. It's a situation where, for very compelling policy reasons, you should look first at probate court. And I believe one of the justices asked a question about Justice Reiber about damages. Who wouldn't want to bypass probate court where you took no action during the first 3 years, as it would be in Vermont, under the statute of limitations, where you have 6 years to, develop your case, I guess, if you want to look at it that way, and then bring it and be able to ask for more damages than you would be able to get in probate court. You can't get punitive damages in probate court, for example. You can get compensatory damages, but you can get potentially a larger recovery and more damages if you sued under the tort. And the states that have adopted the probate exhaustion limitation for good policy reasons say, we don't want to do that. We don't want to encourage undermining the probate system of laws that was legislatively enacted, that has a whole body of law and case interpretation of that, to put all of that aside and then flood the courts, with all of these intentional torts where there's already an established procedure to handle it, and where you can get the finality, the timeliness that is the goal. And as Attorney Barnard referenced, that's what you want. We don't want open cases for years in the court, or have disgruntled heirs go to probate court and then say, well, I didn't like that. Let me go here, or let me bypass probate court. That would sow confusion and uncertainty in the courts. We have scarce resources as it is. It makes no logical policy sense. And I think the body of law that both of us have referenced in all of our briefs really shows that that is the critical consideration of all the states that have addressed.
So, Ms. Ennis, I want to go through one of those cases that you cited, which is the Gerudo case that you rely on from New Jersey.
Mhm.
I know both parties cited it, but doesn't that case also draw the distinction between wills and trusts for the availability of a tort remedy? Because trusts, unlike wills, need not be probated.
Well, I think that depends on the laws of the state. Obviously, trusts.
You cite Gerudo, so tell me.
Yeah.
So tell me if that's wrong.
It's not wrong that trusts don't have to be probated. But what varies from state to state is what their probate code provides for. And so I cite Gerudo to say, in a state where the probate code encompasses trust administration and trust disputes, that needs to be the first stop when you're considering whether there's availability of the IIEI tort. So that's the distinction I draw there. And for sure, and I'll address Sachs v. Dissinger, which is sort of the outlier case. It's the only case that really discusses this in depth. I'll agree with Attorney Barnard there. But what that also ignores is, again, this policy distinction. And it gets back to the third restatement of torts. There's no mention in the third restatement that you have to have preemptive judicial review of a will. Or a trust, for that matter, before you could bring that tort. And in fact, the third restatement deliberately says in the comments that deliberately says in the comments that the individual tortfeasor that malfeasance is encompassed. It deliberately distinguishes that and says, I think one of the comments says, yes, we understand that some scholars and states may say, well, that's not good because that lets the tortfeasor off the hook. But it's a policy decision that on balance overall balances what's best for the most cases, right? So everybody can get a remedy, but they can't all get the remedy in the way they want just because they don't like the way the law is written.
May I move you off
Sure.
the tort claim for a minute?
Sure.
And talk about the breach of contract? Why isn't the statement that I'm under no contractual obligation to include you in my wills, why isn't that an anticipatory breach?
Because he hasn't taken them out of the will.
But why would you make the statement if you don't intend to?
Well, we're here on a summary judgment motion where we have to presume that what Attorney Barnard is alleging is true. So under that construct, my client never said he wasn't going to perform. He said, I don't think there's a contract and I don't think I have to perform, but he already did perform, and he performed actually before the contract was even allegedly made. So how can it be a breach on a very basic level? How can it be a breach if he's performed the contract?
Well, because he can change it. I
He
mean,
can change it, but he hasn't changed it. And that's what the trial court found, especially under the promissory estoppel. Where's the detrimental reliance? There's been no damages. He hasn't changed his will. He hasn't disinherited these two women. And if and when he does, then arguably there would be a breach of contract claim.
So but if he were to change his will, do you agree that there would be a cause of action?
I believe that arguably there would be a cause of action, yes. I mean, again, we're presuming that a contract exists, as was pointed out. I think you pointed out there's no writing evidencing a contract. It makes no sense that a contract was created when my client already had provided for them in his will. And as was also pointed out, there's the benefit of counsel. Everybody agrees that wills are freely revocable and ambulatory, so it makes no sense that a contract would be formed, that he would never change it. He has the right to change it, but under contract principles, strictly contract principles, here's a contract that hasn't been breached.
Does he have the right to change it if he promised that that the two appellants would be the beneficiaries of his will, and allowing the modification of the revocable trust when the settler was still alive?
I suppose. Yeah, I mean, he can always change his will. I think that the terms of the contract, as have been alleged, are that Beryl and Cordelia Dewdney would remain the sole heirs no matter what under his will. So if he changed his will in any way, but they still were the sole heirs, I believe that comports with the contract as it was represented to be. The contract was not represented to be that my client would receive an increased distribution from the revocable trust, hold on to it for his entire lifetime, never use it in any way, and then leave it to them when he died. I mean, in that case, as I had argued, there would be no contract because there's no benefit, however slight, to him for doing that. None. If the benefit was he was going to get an increased distribution and could spend some of it in his lifetime, but leave the rest to them, but with the allegations he's supposed to give them everything when he dies, that makes no sense. There's no benefit to him. And if there's no benefit, there's no contract at all.
You say that he can spend some of it. Isn't he free to spend all of it?
He is, but I'm just dovetailing on what Attorney Barnard said, that the understanding was that he could spend some of it, so it wasn't 100%. But it just doesn't add up. And he didn't promise, the allegation of his contract wasn't that he would keep so much of it or spend whatever percent of it. It was that he would make them the sole heirs.
So they could be heirs to nothing.
They could be heirs to nothing, and they could be heirs to a lot more. He could have wealth from other areas that he would be forced to leave. And it's not confined to just any distribution he may receive in his lifetime from this particular trust. And so again, nobody is gonna know until he dies whether there's any money in the estate or any assets in the estate, what they're gonna inherit. So to me, it just does not add up as a valid contract, but presuming for the purposes of this venue that it is a valid contract, he has not breached the contract. And there is, as Judge Barrow found in the trial court, an anticipatory breach. Principles in general could apply to this situation, but he found it didn't apply because this contract has already been arguably fully performed, but at least partially performed by Ms. Dewdney before she passed away.
And would you agree that he has as being the trustee and he gets a certain percentage and the appellants get a certain percentage, that he has a fiduciary responsibility to the appellants to manage the trust appropriately?
Absolutely. And he is. I mean, there's no allegation that he isn't. You know, managing the trust, he's distributed, in fact, he's given them more than they were actually allowed under the trust, which is not really an issue here, but he has managed the trust. There's been no claim that he's breached his fiduciary duty, except in the context of what Attorney Barnard alleges for this intentional tort. And I see that my time is up, but I thank you for your consideration and ask you to affirm the trial court's ruling in all regards.
Thanks very much. Does the appellant have any time?
Appellant has 0 time remaining.
Okay.